So let us discuss the contract of pledge. Okay. So pledge may be defined as a contract by virtue of which the debtor delivers to the creditor or a third person a movable or a document evidencing incorporeal rights over movables. Okay, for the purpose of securing the fulfillment of a principal obligation, with the understanding that when the obligation is fulfilled, the thing delivered shall be returned with all its fruits and accessions. So, in the contract of pledge class, okay, the thing involved, the thing which is the subject matter of the pledge, okay, will be the possession of which will be transferred from the debtor to the creditor. So there is actual transfer of possession, okay, and it is required in pledge that the possession of the thing should be transferred from the debtor to the creditor. Okay, unless there is no transfer, then there is no pledge. But take note, class, that even if there was transfer of possession, there is never a transfer of ownership. Okay? Iba ang ibig sabihin ng possession sa ownership. Possession it just means that you are holding physically, you are holding the thing, but you may not be the owner thereof. Okay? So in pledge class, because pledge is prenda, okay, when the thing is delivered to the creditor, there is no transfer of ownership. The thing is only held by the creditor as a security for the fulfillment of a principal obligation. So there is no transfer of ownership class, that is very important. Take note of that. So are the parties to the contract of pledge. Okay. We have the pledger and the pledgee. Okay, if you apply your obligations in contracts, the pledger is the debtor or the obligor or the passive subject. The pledgee is the creditor, the obligee or the active subject. Okay? Because the pledger, yung mag-prenda pledger, siya yung may obligation to deliver the thing. Remember class, we are talking about the pledge, we are not talking about the principal obligation. So in the contract of pledge, okay, the obligation to deliver lies with the pledger. Siya yung mag-pledge, pledger. So siya ang debtor, obligor or passive subject. While the pledgee is insofar as the pledge is concerned, wala naman siyang obligation talaga. He is the only one who can demand the fulfillment of the delivery of the thing pledges. Siya yung creditor, obligee or subject matter. Or subject matter, I mean, it's active subject. Subject matter. What is the subject matter of pledge? Take note class that pledge only applies to movables or personal property. Okay. Sometimes it can be incorporeal rights evidenced by negotiable instruments, bills of lading, shares of stocks, bonds, warehouse receipts, and similar documents. Okay. So take note, ang incorporeal rights class are invisible in okay. Yung word na incorporeal, ang root word niyan is corpus. Corpus means body. Okay. Then you have the suffix real. So real body. Tapos may prefix na in, which means not. So incorporeal, not real body. Okay, that is intangible rights. So these rights, although they cannot be said to be movables or personal property, but by provision of the Civil Code, these incorporeal rights, basta evidenced by a document like a negotiable instrument, bill of lading, shares of stocks, bonds, shares receipts, and other documents, okay, they can be a subject matter of pledge. But take note, these incorporeal rights, okay, involves personal property pa rin, like uh, shares of stocks, okay, bonds, pero uh, negotiable instruments will be discussed in the next topic. Okay. Negotiable instruments class example na lang para may may idea kayo is check eh. Okay. Bills of lading. Okay. Bills of lading. It refers to voluminous goods. Okay. It may be loaded on a boat. Naka-load siya doon. Delay down siya doon. Kaya bill of lading. Okay. If you are the owner of that goods, okay, bibigyan ka ng papel evidencing that you are the owner thereof, and that papel is called bill of lading. Kung sa airplane naman, it's called an airway bill. Okay. So, yung papel is an evidence of your right over the goods. Shares of stocks, alam niyo na yan. Bonds also. Okay. It is evidence that somebody owed you some amount. Okay. Warehouse receipts. Kapag ang goods nasa warehouse na, from the boat or from the airplane, nilagay na sa warehouse, merong warehouse receipts. Okay. Kung gusto mo i-pledge yung goods, you pledge the warehouse receipt or the bill of lading as proof na you are, kasi hindi mo ma-claim yung goods hindi mo hawak yung bill of lading, hindi mo hawak yung warehouse receipt. So if iprenda mo yung documents na yun, it is as if yung possession over the goods has been transferred from the pledger to the pledgee, because the pledgee is not the pledger is not anymore in possession of the documents na magka-claim siya ng goods, nandoon na sa pledgee. So yung possession is constructively transferred from the pledger to the pledgee. So therefore, do not just think that the subject matter of pledge are only movables or personal property. Well, in general, they are. The pledge only involves movables and property. Now take note that, sabi ng civil code, incorporeal rights basta evidenced by these kinds of documents may also be subject of pledge. Ang kailangan lang, you have to deliver these documents to the pledger. If you are to the pledgee, if you are the pledger. So efficient cost. Okay. Of course, the security of the principal obligation. So why is it that in pledge, it is the obligation of the pledger to deliver the possession of the thing to the pledger? The cause is because it is to secure a principal obligation. Usually, in actual scenario, it is utang. Okay? Kaya kagaprenda dahil may utang. So yun ang cause, yung security. In layman's term, it's some form of a collateral. So important, yan, naka-mention ito sa terms of specifications and sa syllabus ng CPA licensure examination. Important daw ito. You have to take note that while pledge binds the pledger and the pledgee, okay, it will not take effect against other persons or third persons basta hindi nakanotaryo, and dapat na sa loob ng document nakasulat ang date of the pledge and the description of the thing. Okay. So that other persons will also be bound to respect the pledge. Okay. It does not mean, class, na pag hindi nakanotaryo, walang pledge. May pledge pa rin, pero this will bind only the pledger and the pledgee. And you cannot expect third persons to acknowledge that there is a pledge. Okay? So that other persons will be bound to acknowledge the pledge, sulat nyo sa instrument, nakasulat ang date and the description of the thing, then ipanotaryo. Okay? So that when you show the document to the third person, they will know that there is this pledge and they cannot attack the truthfulness of that pledge. So characteristic of pledge, number one, it is a real contract. Okay. Take note, class, you are not talking about the real obligation but real contract. Kasi real obligation, diba, is obligation to deliver. Okay, but a real contract means the contract is perfected by the delivery of the thing. Okay, ang kabaliktaran nito is consensual. Consensual contract like sales is perfected by the mere meeting of the minds. Okay? In the contract or pledge, even if there is already meeting of the minds, basta hindi pa na-deliver yung thing, there is no pledge. Because the delivery of the thing will perfect. That is the time na mag-perfect na contract of pledge. Why? Because if you have to think about it, walang prenda hanggat hindi mo siya dineliver. Yung thing. Hindi pwede na nagprenda ka tapos ang thing na sa'yo pa rin. There is no pledge. So for the contract of pledge to be perfected, you have to deliver the thing. Okay, that is why pledge is not a consensual contract, but it is a real contract. It is perfected by the delivery of the thing. It is not perfected by the meeting of the minds. Number 2, accessory contract. Pledge is an accessory contract because it cannot stand alone. It is dependent upon a principal contract. There is no pledge if there is no principal contract. And take note, as discussed in the previous lesson, pledge and mortgage can secure all kinds of contract. So because we are discussing pledge, a pledge is required to be an accessory to a principal contract. And in actual situation, most probably this principal contract is utang. Okay, may prenda dahil may utang. Hindi pwede magkaroon ng prenda nang walang utang. Because the contract of pledge cannot stand alone on its own. Pledge is a unilateral contract. Unilateral because only the pledger has the obligation to deliver. Okay. The pledgee has nothing to do but to accept or demand. Wala siyang obligation. I-accept niya lang yung delivery. Unlike sa sales na bilateral, na ang vendor has to deliver and the vendor has to pay. Ganun ang bilateral, like sa sales. But in a contract of pledge, the pledge is a unilateral contract. Only the pledger has the obligation, which is the obligation to deliver the thing pledge. Number 4, it is a subsidiary contract. Pledge is a subsidiary contract because the obligation incurred does not arise until the fulfillment of the principal obligation to which it is secured. Okay. Subsidiary contract siya kasi ibig sabihin, on standby lang siya. Kung standby lang siya, okay, yung obligation will not arise until the fulfillment of the principal obligation to which it is secured. Ibig sabihin, yung principal contract talaga is ang principal obligation, then subsidiary na lang ang pledge. Essential elements. Okay, relate mo ito doon sa essential elements ng unang lesson on pledge and mortgage. Okay, 1, 2, 3. Ito yung essential elements common to pledge and mortgage. But this time, let us talk about the essential elements of pledge. Number 1, it is constituted to secure the fulfillment of a principal obligation. Number 2, the pledger should be the absolute owner of the thing. The person constituting the pledge has the predisposal of their property, or in the absence thereof, that he be legally authorized for the purpose. So, na-discuss na ito sa last lesson. Then, number 4, the thing pledged must be delivered to the creditor or the third party by common agreement. So, itong number 4, nadagdag ito dahil we are already discussing pledge. Yung 1, 2, 3 is common elements ng pledge and mortgage. Yung number 4, dagdag lang dahil we are already in the lesson concerning pledge. Take note class that in pledge, it may be delivered to the creditor or to a third person by common agreement. Pwede pala, according to number 4, pwede ang prenda hinawakan ng another person. Okay? Basta nag-agree ang parties. So, I am the pledger and you are the pledgee, and we we agreed na ipahawak yung thing kay third party, pwede yun. So, pwede pala ipatago sa ibang tao yung nakaprenda na bagay. So, these are the provisions of the Civil Code applicable only to pledge. Number 1, the pledger retains ownership. Okay nga, kasi nga, ang discussion natin is, in pledge, there is no transfer of ownership. Kasi security lang siya. Okay? Hindi tulad ng sa sales, there should be transfer of ownership. So, in pledge, there is no transfer of ownership, only transfer of possession. So, the pledger, yung nagprenda, siya pa rin ang may-ari. He remains to be the owner of the thing, even if the thing is already in the possession of the pledgee. So, the pledger is still the owner. And as such, dahil siya pa rin ang owner, can do things you can do actions pertaining to the thing as an owner. In fact, pwede niya ibenta basta with the consent of the pledgee. Si pledger, being the owner, can still sell the thing basta may approval ni pledgee. And the buyer of the thing, the third person who buys the thing, will become the new pledger. Of course, you should know na nakaprenda yung thing. Okay? And he must agree that he is already the new pledger so that the pledge can go on. If hindi siya mag-agree, then they should agree whether or not the pledge should still exist or that the pledger should deliver another property in lieu of the thing that was sold. But what is important here, class, is that the thing remains to be the ownership of the pledger, and he can sell it if he wants with the permission, with the approval of the pledgee. Okay. Just in case lang na binenta niya, then nag-agree sila, pati yung bumili na tuloy pa rin ang prenda, then the thing is still with the pledgee, but the new owner is the third party, who is now the new pledger. Okay. Pero yung thing, nandun pa rin sa pledgee, kasi nga prenda. He must continue to be in possession thereof. Okay, next, the possession of the pledgee, the possession of the pledgee constitutes his security. So, yun talaga ang parang collateral. Hence, the debtor cannot demand for its return until the debt secured is paid. But the right of retention is limited only to the fulfillment of the principal obligation for which the pledge was created. So dahil prenda ito, surrender mo yung possession ng thing. If you are the pledger, you cannot demand the return until such time that the principal obligation, which most often is a debt, pag hindi pa nabayaran, hindi pa pwede i-demand ang return. But once the principal obligation or the debt has been fulfilled or paid, okay, the pledge cannot anymore be retained for other purposes. Ibalik na dapat. Because the purpose of the pledge is only to secure the principal obligation. So that if the principal obligation is paid, then the pledgee has to return the thing. If there are other obligations, yung pledger sa pledgee na not covered by the pledge, hindi niya pwede i-retain ang thing for purposes other than that na sa pledge. If the principal obligation has been paid, ibalik niya na yung thing. Okay. So, kung may ibang atraso pa sa kanyang pledger, hindi niya pwede i-hold ang thing. Kasi yung thing is only for the principal obligation. Next one, the pledgee has the obligation to take care of the thing with the diligence of a good father of the family. Okay, so, I am the pledger, ako may-ari, ikaw ang pledgee. Giprenda ko sa iyo yung thing dahil may utang ko sa iyo. So, because you are in possession of the thing that is not yours, because there is no transfer of ownership, that is mine, but because you are in possession of that thing, you must take care of it with the diligence of the good father of the family. Okay. Actually, ang mag-worry dapat si pledger, baka si pledgee hindi marunong take care of the thing. Okay? So the law says, Hoy pledgee, because you are in possession, even if you are not the owner, you have to take care of that thing with the diligence of a good father of the family. Okay? So if he has made expenses for the preservation of the thing, okay, si pledgee, siya ang nag-alaga, then may nagastos siya to preserve, then he can demand reimbursement from the owner or the pledger, okay, because the expenses was necessary to preserve the thing. Okay, for as long as there is no fraud, negligence, delay, or violation of the contract. Because if the pledge is liable of fraud, negligence, delay, and violation, then you cannot ask for reimbursement. Okay, so the pledgee is not authorized to transfer possession of the thing pledged to a third person unless otherwise stipulated. Okay, so if the agreement was to make the pledgee the possessor, so nasa pledgee yung possession, hindi niya basta-basta ilipat ang possession sa ibang tao without the knowledge and approval of the pledgor. Kasi nga, si pledgor naman talaga ang may-ari. Okay? So, si pledgee, hawak niya lang. He cannot, because he is not the owner, he cannot just transfer the possession or ipatago sa ibang tao without the knowledge and the approval of the pledgor. So, the pledgee has no right to use the thing pledged or to appropriate the fruits thereof without authority of the owner. Okay? So, yung thing nakay pledgee. Pledgee is not the owner. The real owner is still the pledgor. Okay? So, even if the pledgee is in possession, he cannot use that thing. Hindi niya pwede gamitin. So, kung gusto niya gamitin yung thing, magpaalam siya sa owner or the pledgor. If the thing produces fruits, okay, that fruits, of course, will be owned still by the owner because of spirit domino. Kung sino yung may-ari ng thing at nagkaroon ng fruits yung thing, then the fruits will also be owned by the owner, the pledgor, not by the pledgee. So the pledgee, even if he is in possession of the thing and the fruits thereof, he cannot use them or appropriate them as his own. Hindi niya pwede angkinin without the authority of the pledgor or the owner. When the preservation of the thing pledged requires its use, it must be used by the creditor but only for that purpose. Okay. So, ang general rule is, ang pledgee, hindi niya pwede gamitin yung thing. Exception, if kailangan gamitin yung thing para ma-preserve. For example, ang nakaprenda is motor, kotse. So, every now and then, kailangan siya i-warm up. Diba? So, pwede warm up ni pledgee kahit walang paalam kay pledgor. Okay, para ma-preserve yung thing, para hindi mamatay yung baterya. Okay, para mag-circulate pa rin yung engine oil sa loob ng engine. And every now and then, pwede niya ikot-ikot lang sa neighborhood for the purpose na hindi ma-brittle yung gulong. Pwede yon, even if without permission. Because the purpose for that is only for the preservation of the thing. And take note, siyempre kailangan niya ng gasolina. So, kung pinagasolinahan niya para ma-warm up, para maikot-ikot ng konti, yung gasolina, he can ask reimbursement from the pledgor because that expense, that gasoline expense, is necessary for the preservation of the thing. Okay, so pwede niya kolektahin, ipa-reimburse kay pledgor. Why? Because it was needed for the preservation of the thing pledged. The pledgee can apply the fruits, income, dividends, if thereafter to the principal of his credit unless otherwise stipulated. Okay, if the thing pledged produces fruits, income, dividends, or interest in the form of money, okay, kapag ang principal obligation is credit or debt, pwede niya kunin yung income, dividends, or interest or the monetary fruits, and it should be compensated doon sa credit. Ibig sabihin, ipambayad. Pwede yun. Unless otherwise stipulated. So, if there is no agreement, pwede niya i-apply. yung income ng thing, pledge, i-apply doon sa principal obligation. Okay, kung utang yon, pwede niya i-compensate doon or i-consider as payment. Pwede yun. Unless they agreed na hindi pwede. Unless they agree na lahat ng fruits and income and dividends in the form of money should be given to the pledger and not applied to the principal obligation. So if there is no agreement, pwede i-apply ni pledge yun to the principal credit. The pledger may ask that the thing pledged be deposited judicially or extrajudicially if si pledger yung may-ari talaga. Okay, worried siya because the thing is with the pledgee. Baka hindi marunong mag-alaga yun si pledgee. So, if he is so worried, he can ask that the thing be deposited judicially sa court or extrajudicially sa other persons if, number one, the creditor uses the thing without authority. Okay. Ginagamit ni pledgee yung thing. Bawal sanang gamitin yun, di ba? Pero ginagamit niya. Hindi naman for preservation, for other purposes. So si pledger, bago nag-worry siya, he can ask that the thing ipahawak na lang sa iba or deposit na lang sa court para mawala yung worry niya. Or when the creditor misuses the thing in any other way. Oh, hindi marunong magamit, gina-misuse ni pledgee yung thing, yung pagmamayari ni pledger. So dahil worried si pledger, he can ask that the thing be deposited judicially sa court or extrajudicially with another person. Or when the thing is in the danger of being lost or impaired because of the negligence or willful act of the pledgee. So the pledger who is the owner, nakikita niya si pledgee na sa kanya yung thing is very negligent or is willfully misusing or damaging the thing pledged. So para mawala ang worry ni pledger, he can ask the pledgee na i-deposit na lang sa court or extrajudicially with another person. The pledger cannot ask for the return of the thing pledged until the principal obligation is fully paid, of course, including interest thereon, kung may interest yung utang, and expenses incurred for its preservation. Okay. Pati yung nagastos ni pledgee sa pag-preserve ng thing should be paid by the pledger. Okay. Not only the principal obligation, but the necessary and useful expenses for the preservation of the thing must also be paid. Kapag kautang lang binayaran niya, hindi niya binayaran yung necessary and useful expenses for the preservation of the thing, pwede pa rin hindi balik sa kanya yung thing. Okay. So, ang bayaran niya, number 1, principal obligation. Number 2, interest, if any. Number 3, necessary and useful expenses for preservation, if there are any. Yung tatlo na yun. Before the thing will be returned to the pledger. However, the pledger is allowed to substitute the thing pledged which is in the danger of destruction or impairment with another thing of the same kind and quality. So, the pledger, okay, is allowed to substitute yung pledge basta pag nakita niya nasisira na, okay, he can substitute that with another thing of the same kind and quality. Of course, simply. If the thing pledge is returned by the pledgee to the pledger or owner, the pledge is extinguished. Take note lang ha. Pagka binalik ni pledgee sa pledger or to the owner, if the pledger is a third party, binalik niya na doon sa third party na yun, na owner, the pledge is extinguished. Wala na, pledge. Pero hindi ibig sabihin na wala na principal obligation. Okay. So, kapag halimbawa, there is a principal obligation in the form of utang, then may prenda, binalik yung prenda. Ibig sabihin, there is no more prenda, but that it does not mean na wala na yung utang. Baka meron pa rin utang. Kaya, baka binalik lang ay ng pledger, maybe because ng pledgee, maybe because he trusts already the pledger and he do not need the pledge anymore and he can collect if he wants. Okay. So any stipulation to the contrary shall be void. So hindi pwede ibalik ni pledgee kay pledger yung thing. Hindi sabi na may prenda pa rin ha, may prenda, hindi pwede. Once the pledgee returns possession to the pledger, there is no more pledge. Okay. Any stipulation to the contrary is void. Okay. If subsequent to the perfection of the pledge, the thing is in the possession of the pledgor, nabalik yung thing sa pledgor or sa owner if third party ang nagprenda, there is a prima facie presumption that the same has been returned by the pledgee. Okay, prima facie presumption. Okay, si pledgee, kapag ninakaw pala ni pledgor yung thing sa kanya, pwede niya i-prove yun. Pero it is a prima facie presumption. Prima facie, ibig sabihin rebuttable, pwede pa i-dispute sa court. Okay. But if the thing has been returned to the pledgor or to the owner, it is a prima facie presumption now na binalik ni pledgee and the pledge will be deemed extinguished. This same presumption exists if the thing pledged is in the possession of a third person who has received it from the pledgor or owner after the constitution of the pledge. Okay. Even if napunta sa third person. Okay. Basta kasi, essential kasi sa pledge is nasa pledgee ang possession. If nawala na sa pledgee ang possession, napunta na sa iba o sa owner or sa pledgor, then the pledge will be extinguished really. Because there is no more security to the principal obligation. So when the thing pledged is later found in the hands of the pledgor or the owner, only the accessory obligation of pledge is presumed remitted, not the principal obligation itself. As mentioned earlier, if the thing is returned, the pledge is extinguished, but it does not necessarily mean that the principal obligation is also extinguished. Okay? It may be that the principal still exists. The principal obligation still exists. Good year. Any third person who has any right in or that thing pledged may satisfy the principal obligation as soon as the latter becomes due and demandable. So any person na may right dun sa thing, even if hindi siya yung pledgor, even if hindi siya owner, may right siya siguro in any other form like guarantor or other rights over the thing. Okay, pwede niya bayaran na lang yung principal obligation kasi may para makuha niya yung thing. Okay. If credit class, ibig sabihin niyan receivables. Okay, mas familiar kayo sa receivables. Which has been pledged becomes due before it is redeemed. The pledgee may collect and receive the amount due, and he shall apply the same to the payment of his claim and deliver the surplus should there be any to the pledgor. Okay, we have mentioned earlier that pwede pala ang incorporeal rights pwede pala prenda. Okay. So, example nun is receivable, right to collect something. Maybe it's a post-dated check, siguro. Pwede rin. Naka-pledge siya. And then, nag-due na, nakolekta ng pledgee. Yung nakolekta niya, can apply that to the payment of the principal obligation. And ang sobra, ibalik niya sa pledgor. Yan ang ibig sabihin niyan. Okay? Before we proceed, I would just like to clarify. Okay? Sa pledge class, may pledgor, may pledgee. Tapos yung thing, i-deliver sa pledgee or to another person na na-agreehan ng pledgor and pledgee. So, in that scenario, yung thing is nandun sa third person, siyang may hawak. It may be also classed that the pledgor and the pledgee may principal obligation, then another person ang nagprenda kay pledgee. Na-gets niyo sana. Okay? So, ang nagprenda is not yung may utang, kundi yung siguro kaibigan niya. Napakiusapan niya na magprenda para makautang siya. So, ibang tao ang pledgor. Tapos binigay niya yung thing doon sa pledgee. Pero may utang talaga, yung isa, yung debtor. So, pwede rin yun. In that case, yung possession na sa pledgee, ang magbabayad ng principal obligation, yung debtor. Pero ang pledgor is another person, third person. Pwede rin na si pledgor and pledgee, nag-agree sila na may pledge, pero another person ang magprenda. kaibigan ni pledgor, ng utang. And then naagrihan nila na yung thing will be held by another person. So, apat ang involved doon. Okay, si pledgor, si pledgee, tapos, hindi pala, si debtor, creditor, sa principal obligation, may utang si debtor kay creditor, and then yung kaibigan ni debtor, napakiusapan niya na siya magprenda, so ni prenda, napag-usapan nila na ang maghawak is another person, so apat silang involved. On the part of the debtor, yung kaibigan niya na nagprenda, on the part of the pledgee, yung pledgee, at saka yung kaibigan niya siguro na naghawak ng thing. Apat silang involved sa pledge. Okay? So, let us proceed. Based on those provisions of the Civil Code pertaining to the pledge, okay, hindi naman nakalista kasi sa Civil Code kung ano yung rights, ano yung obligations. Okay. Kailangan basahin mo yung provisions so that you can make your own list. Nagawa ko ng aking list. The rights of the pledgee according to the provisions of the Civil Code. Number 1 is to retain the thing pledge as security for the principal obligation. Of course, si pledgee. Okay, karapatan niya hawakan yung thing. And actually, it is essential and necessary for the pledge that the thing be in the possession of the pledgee. Si pledgee yung giprendahan. This is under Article 2098. Na ang second one, to compensate the earnings of the thing pledged with the principal debt. Okay? So, kung yung thing is producing money, then you can apply the money to the principal obligation, pambayad sa principal debt. So, diyan. Basta, if may sobra, ibalik nyo doon sa pledgor. To cause the public sale of the thing pledged if it is in the danger of destruction, impairment, or diminution, there being no fault on the part of the pledgee. Okay. Number 3, ibig sabihin, pledgor and pledgee, nagprenda ng thing. Pero yung thing, nasa possession ng pledgee, walang kasalanan sa pledgee, but the thing is deteriorating. Nasisira, unti-unti nasisira. The pledgee can sold that in public auction. Ipa-auction niya. Okay? Para yung security ng principal obligation, hindi ma-diminish ang value. Okay? Yung proceeds, yun na yung magiging substitute ng pledge. Okay? So, pwede yun. Basta in the danger of destruction, impairment, or diminution with the fault of the pledgee. Dapat hindi kasalanan ng pledgee. Dapat natural lang siya na nasisira. So, to prevent further destruction, further impairment, pwede ibenta ni pledgee on public auction. Okay? Para hindi magbaba ang value ng security. Number 4, to demand substitute or immediate payment if he was deceived on the substance and quality of the thing pledged. Okay. Si pledgor, nagprenda kay pledgee ng thing. Sabi ni pledgor, brand new yan. Magandang klase, magandang quality. But the pledgee found out later on na niloko lang siya ni pledgor. So, he has the right to demand for a substitute. Yan yung number 4. Number 5, to cause the thing pledged to be sold at public auction when the creditor has not been satisfied in due time. Ito naman, public auction dahil hindi makabayad yung pledgor, yung debtor. Yung debtor, hindi makabayad. So, ang pambayad nun is yung thing pledged is sold at public auction. Ang proceeds, yun ang doon kunin na pambayad. Okay. This public auction is different doon sa number 3 kanina. Yung number 3 kasi dahan-dahan nasisira yung thing, so para hindi na sa tuloy masira, benta na lang sa public auction kaagad. Itong number 5 is natapos na ang due date, hindi pa nakabayad o hindi na makabayad or hindi ayaw na magbayad ng debtor or ng pledgor, then the pledgee can sell that for public auction, then yung proceeds, yun ang pangbayad doon sa principal obligation. Ito yun. Number 6, to choose which of the several things pledged shall be sold at public auction. So, if there are several things na gi-pledge, okay, the pledgee has the right to choose kung saan doon ang pwede i-benta. Number 7, to appropriate the thing pledged after 2 failed auctions. Now, take note in our previous lesson, hindi pwede i-appropriate ang thing because that is pactum commissorium. Pero pwede niya i-appropriate basta after 2 failed auctions. Pwede na i-appropriate. Yun ang requirement ng law. This is not pactum commissorium because may 2 attempts na to sell at public auction. Kaya lang, ay hindi ayaw talaga bumili yung mga tao. That's the time that the thing can be appropriated by the pledgee. Number 8, pwede rin siya sumali sa public auction. Siya ang nagpa-auction, pwede rin siya sumali. Okay? Obligations of the pledgee. So, anong obligation ni pledgee? Si pledgee ha, yung may hawak ng thing sa kanya giprenda. Kanina yung rights of the pledgee. Now, the obligation. The obligation of the pledgee is to take care of the thing with the diligence of a good father of the family because he is in possession. Even if he is not the owner, he must take care of the thing with the diligence of the good father of the family. Okay, not to deposit with a third person if he is not authorized. So, hindi niya pwede ipahawak sa iba basta hindi siya authorized by the pledger. Number 3, not to use the thing pledged if not authorized. So, hindi niya pwede gamitin unless authorized. Unless the use is for the preservation of the thing. Because kung ang use niya is for the preservation of the thing, that is considered authorized. Number 4, to advise the pledger or owner of the result of the public auction. Of course, kailangan pag ibenta niya na, i-advise niya, sabihin niya yung pledger or yung owner or yung pledger, no, nabenta ko na sa public auction yung thing. He has to report. Why? Because the real owner really is the pledger or the third person who owns that. Take note class, sa pledge walang transfer of ownership. Pero pag nabenta na sa public auction, there is already transfer of ownership. So, ano na napunta yung ownership? The ownership will be transferred to the buyer sa public auction. Okay? Rights of the pledger. Now, this time the pledger, rights niya. As the owner, because he is still the owner, even if he is not in the possession, he has the right to bring action to defend or recover the thing pledged from the third persons. Okay? So, being the owner, kahit nawala sa kanya yung thing, he can still defend the thing. He can still recover ng thing kung gikuha ng ibang tao. Okay? Because he is the real owner. To ask that the thing pledge be deposited judicially or extrajudicially if the pledge misuses the thing pledge. Okay, pag i-misuse ng pledge, yung thing na pagmamayari niya, he has the right to ask that it be deposited judicially sa court or extrajudicially with another person. Number 3, to demand the return of the thing pledge after fulfillment of the principal obligation. Okay, if nakabayad na siya ng principal obligation, then he has the right to demand na ibalik sa kanya yung thing. Number 4, to ask that the thing pledge be deposited with the third person if negligent yung pledgee. He has the right. Kasi sa kanya yung thing. So, di niya i-demand, ibigay na, ipahawak na sa ibang tao. Baka masira or mawala yung thing. To substitute the thing pledge if there are reasonable grounds to fear the destruction and impairment of the thing pledge without the fault of the pledgee. So, pwede niya palitan. Number 6, to bid at the public auction. Pwede rin siya mag-bid. Okay? And to receive the excess if stipulated. Kapag katapos ng public auction, pag may sobrang pera, he can demand to receive the excess if they agreed that the excess will be given to the pledger. So, obligations of the pledger. Okay? To deliver the thing to the pledgee. Of course, that is the essence of pledge. Deliver niya talaga. Number 2, to advise the pledgee about the flaws of the thing pledge. Okay, kung may sira or may defect yung thing, dapat i-advise niya yung pledgee. Okay, para alam ng pledgee. Because if there are flaws in the thing, hindi alam ni pledgee, tapos na damage si pledgee, then liable si pledger. Because he did not advise the pledgee. So, rights of the third person, so any right on the thing pledge, okay, kahit yung ibang tao basta may right sila over the thing, meron siyang right to satisfy the principal obligation. Pwede niya bayaran na lang para wala na yung obligation, mawala na yung pledge. Pwede yan. Kahit na hindi siya kasali sa pledge. Basta may right siya over the thing. Extinguishment, how is a pledge extinguished? Number 1, by the fulfillment of the principal obligation. Okay, binayaran yung utang, wala nang prenda. Extinguished na. Okay? By return of the thing pledge. Okay? Basta binalik yung thing, even if meron pang utang, the pledge is extinguished. Okay? Pero yung utang, continue yun. Pero yung ang pledge ang pinag-uusapan natin dito, because the thing is returned, there is no more pledge. By renunciation or abandonment. Okay, of course, pag binalik na ng pledge yung thing, dahil ayaw niya na ng prenda, pwede rin yun. Extinguish na yung pledge. Very important class, public auction. Sa public auction, we already know na pag ayaw magbayad or hindi na makabayad si debtor kay creditor, tapos may pledge, okay, the pledgee, siya yung creditor, he can sell the thing at public auction. Paano yun? Paano process nun? Number 1, the creditor to whom the credit has not been satisfied in due time may proceed before a notary public to the sale of the thing pledged. So, punta ka sa abogado na notaryo publiko. Okay. Doon ka magpatulong because siya ang mag-notarize ng public auction. Siya ang mag-allow ng public auction. Siya ang mag-authorize. Number 1, this sale shall be made at public auction. Public auction talaga. Announce to the public. And with notification to the debtor and the owner of the thing. I-notify din yung may-ari or yung prenda. Stating the amount, kung magkano, yung for public auction. At saka kung saan yung public auction o public. Public auction, public sale, para lang pa sa. Number 2, if at the first auction the thing is not sold, a second with the same formalities, with the same procedure shall be held. Dalawang beses. Number 3, if the second auction there is still no more sale, no sale yet, the creditor may appropriate, o ginamit dito, appropriate, pwede niya na iangkin the thing pledge. In this case, he shall be obliged to give an acquittal for his entire claim. Okay? Dahil na napasa kanya na yung thing, for whatever value, for whatever amount, it shall be considered that the principal obligation has been totally fulfilled or totally paid. So that the creditor cannot anymore run after the debtor for any deficiency. And then at the public auction, the pledger or owner may bid. Of course, pwede sila mag-bid, sila lahat, pati si pledgee. He shall moreover have a better right if he should offer the same terms as the highest bidder. So kung dalawang highest bidder, yung isa, yung may-ari or yung pledger, priority yung may-ari or yung pledger. The pledgee may also bid, but his offer shall not be valid if he is the only bidder. So hintayin niya muna ng 2 failed auctions bago mapasa kanya yung thing. All bids at public auction shall offer to pay the purchase price at once. If any other bid is accepted, the pledge is deemed to have been received. The purchase price as for the pledger or owner is concerned. So the purchase price must be paid at once. Wala nang hindi pwede installment. If pumayag yung pledge na installment, it is considered na paid na yung total amount ng price. Okay. Later on, if hindi nagbayad ng installment yung buyer sa public auction, hindi na kasalanan ng pledger. Yung pledgee ang pumayag, siyang liable doon. The sale of the thing pledged shall extinguish the principal obligation whether or not the proceeds of the sale is equal to the amount of the principal obligation, interest, expenses in a proper case. Very important class kaya siya naka-underline. Whatever the amount of the proceeds sa public auction, basta pledge, if the principal obligation is considered to be totally extinguished kahit na yung proceeds kulang. Okay? Kapag kulang yung proceeds, considered pa rin na paid ang buong principal obligation. And the creditor pledgee cannot anymore run after the debtor or the pledgee. So what if the price is more than the amount? Sabi ng batas na kasulat sa law, sa civil code, the debtor is not entitled to the excess also. Unless nag-agree sila na ibalik. But the general rule is that sa pledge class, take note of this, sa pledge class, whether kulang or sobra, hindi na pwede ibalik or habulin ang debtor unless nag-agree sila otherwise. Number 2, if the price of the pledge is less, then the creditor cannot recover the deficiency with notwithstanding any stipulation to the contrary. Okay. So, ang pwede lang nila agreehan is kung ibalik ba o hindi ang sobra. Pero yung kulang, hindi sila pwede mag-agree because the law says kahit mag-agree kayo dyan, the entire obligation is considered fully paid, even if deficient. So, therefore, ang pwede nila agreehan is only on the excess, whether ibalik ba o hindi. If hindi sila nag-agree, then the excess will not be returned by clear provision of the Civil Code, Article 2115. So, after the public auction, the pledgee shall promptly advise the pledger or the owner of the resort. If 2 or more things are pledged, the pledgee may choose which he will cause to be sold. Ayan, pwede niya piliin. He may demand the sale of only as many as the things as necessary for the payment of the debt. That is self-explanatory. Legal pledge. Okay, yung pinag-usapan natin kanina, ang tawag doon, conventional pledge. Conventional because it is agreed by the pledger and the pledgee. Then we also have this legal pledge. Legal pledge class, pledge din siya, pero based on law, kaya legal. These are pledges by operation of law. Okay? They are also governed by the rules on the possession, care, and the sale of the thing, as well as the termination or extinguishment of the pledge. However, after payment of the debt and expenses, the remainder of the price of the sale shall be delivered to the obligor. Okay? So, sa conventional pledge class, yung public auction, pag may sobra, hindi na ibalik. Unless, nag-agree sila na ibalik. Pero sa legal pledge class, yung pledge na by operation of law, ibalik talaga ang sobra. Okay? So, ano-ano yung legal pledge? Number 1 is Article 546 of the Civil Code. Okay? So, yung mga useful necessary expenses for the preservation in good faith. Okay, pag ayaw bayaran, the thing held shall be considered as like a pledge. Okay? So, if you can still remember in our obligations and contracts, meron yung necessary and useful expenses na sinasabi natin. Okay? Iba yung may hawak ng thing. Wala naman silang contract. Okay, nasa kanya lang yung thing. And he spent for necessary expenses and useful expenses for the preservation of the thing. Yung may-ari must reimburse. If you will not reimburse, then yung thing will be considered just like pledge. Pwede ibenta sa public auction. Pambayad doon sa expenses. And then, ang excess will be returned to the owner of the thing. Number 2 is Article 1731. Any person who has work on a movable has the right to retain it by way of pledge. Okay, so may movable thing, pinagawa mo sa iba. Or meron kang isang thing na pinayos mo, ayaw mo bayaran. Yung nagtrabaho doon, he can retain that thing just like in pledge. Kung ayaw mo bayaran yung ginawa niya, yung trabaho niya, he can sell that in public auction and then yung proceeds pambayad doon sa inutang, sa hindi mo ba ayaw mo bayaran, and ang proceeds, ang sobra ibalik doon sa may-ari. Also, Article 1994, the depositary may retain the thing in pledge until the payment of the may due him by reason of the deposit. Okay, sa contract of deposit class, pwede mo, halimbawa, punta ka ng ibang bansa, yung mga properties mo, pinahawak mo muna sa isang depositary. Ikaw yung depositor, yung hawak depositary, sabi mo, bayaran lang kita for taking care of my things. And then, you refuse to pay later on, okay, the depositary, who is in possession of the thing, can treat that as a pledge and he can sell that at public auction para yung utang mo will be taken from the proceeds, ang sobra ibalik. Okay. So this 1, 2, 3 are called legal pledges because this is the law says that the parties here can, especially the the person who has a claim, can consider the thing in his possession just like pledge. Basta ibalik lang sobra, basta may public auction. Okay, a thing under the pledge by operation of law. Okay, when you say pledge by operation of law, it is legal pledge. May be sold only after demand of the amount for which the thing is retained. So if you are a person who has a thing in your possession and you have a claim doon sa may-ari, just like in legal pledge, okay, mag-demand ka muna. Huwag mo ibenta diretso sa public auction. Mag-demand ka muna na bayaran. If hindi ka bayaran, that is the time you can sell it at public auction. When will you, in legal pledge, when will you perform the public auction? Within 1 month from the demand. If there is no public auction after the demand within 1 month, wala kang naka-public sale or public auction, the debtor may require the return of the thing. Pwede na bawiin sa iyo yung thing. Kasi parang give-wave mo na yung public auction. With regard to pawn shop and other establishment, they are governed by special law and of course with the provision of the civil code. So, applicable pa rin itong mga pledge sa pawn shops. Dagdag sa special law about special law class is another law nag-regulate sa mga pawn shop and other pawn shop like establishment. But the provisions of the civil code will also apply to pawn shops and other establishments. So that is the end of pledge. Okay, the next lesson will be mortgage.